The contract's professional responsibility crossover question from July of 1995 is an enormously useful fact pattern. It's useful not only because it's a good crossover question, but perhaps more importantly, it's a really good contracts question, and it focuses our attention on some issues that are far more commonly tested on the multi-state than on the essays. Take a look with me at the call of the question. 1. Is Lab entitled to terminate the contract with DISCO? Discuss. Well, that's interesting. It's a question that is seeking to test us on a party's ability to rescind a contract. So it's a remedies question, and contracts provide the theory of liability. In order to answer this question, whether or not Lab is entitled to terminate the contract, we first have to examine the contract, focus on the alleged breach, and then make a conclusion one way or another. Rescission, or canceling a contract, is a pretty severe remedy, and it won't be granted without fairly extreme facts. 2. What ethical issues arise from Lab's request that its attorney use the information regarding DISCO's violations of environmental regulations to encourage DISCO not to press its contract claim? Discuss. Well, we'll have to look at the facts to get really specific, but we have some idea about what the black-letter law is going into this problem. We know that it is not per se unethical for a lawyer to threaten an adversary with potential criminal prosecution or other civil action so long as the threat is made in good faith. And I realize that sounds a little bit like a contradiction in terms, the idea that a threat can be made in good faith. But as we look at the analysis, you'll see what I mean and how it plays out, if you aren't already quite familiar with the law. So we've got a tricky pair of calls of the question. Neither of them are very conventional, and thus both of them are well worth our examination. So now let's go up and take a look at the fact pattern itself. In paragraph 1, we get the facts about the contract between Lab and disposal specialist company DISCO. And we get the details. Disposal of hazardous waste for 5 years with a $45,000 per year cost. And it turns out that the entire dispute is going to center around the clause in paragraph 8D, which is quoted at the end of paragraph 1. Well, DISCO agrees to remove the specified waste products from the Lab site within 48 hours of being notified that Lab's waste containment vessel is filled. Okay, it's a pretty clear-cut contract term. In paragraph 2, we find out about the situation that caused the Lab to seek the termination of the agreement. We find out that at 4:30 in the afternoon on Friday the 26th of May, Lab notifies DISCO that the waste containment vessel is 90% fill. Well, that doesn't look like proper performance on the part of Lab, does it? The notification was supposed to be made at the time the containment vessel was 80% filled. And the DISCO manager responds in the same paragraph here, paragraph 2, that the waste can't be picked up until Tuesday because of the Memorial Day holiday. And, in fact, DISCO empties the container on Tuesday morning early, but Lab's work was interrupted, and Lab incurred losses of $9,000. Well, unless there's something more to it than the facts in this second paragraph, I don't think Lab is going to be entitled to terminate the contract with DISCO, because terminating the agreement basically is an equitable remedy, and Lab has unclean hands. I almost laugh saying the phrase in the context of this fact pattern, but it's true. If the containment vessel was 10% more filled than the contract provision stated it needed to be, certainly it seems unreasonable to penalize the disposal company for the $9,000 losses suffered by Lab. Now, take a look at paragraph 3. Here, on June 10, Lab informs DISCO that it is terminating the contract because of the delayed pickup. Then we get more very important facts. The DISCO manager actually replies and says the 48-hour deadline didn't apply over holiday weekends and that he had mentioned this during the 1991 contract negotiations. In fact, we are told DISCO has gone beyond the 48-hour period on at least 4 holiday weekends during the last 3 years without complaint from lab. And here's another defense to equity: waiver. Then we see that twice the lab waste manager had approved a holiday weekend pickup 96 hours after notice. DISCO's manager threatened to sue lab if it tried to terminate the agreement, and it looks like they would have a good reason to do so. This June 10, 1995 communication looks to me rather like an anticipatory repudiation rather than some act of an aggrieved party who has been wronged by the other. Paragraph 4, we've got the lab waste manager telling the attorney for lab that DISCO has committed criminal violations of environmental laws in its waste disposal operations, and that he expects the attorney to use this information to convince DISCO to agree to cancel the contract. Well, that's pretty useful. And we find that the ethical issues presented, again, are fairly straightforward. And when we get to the outline of issues, you'll see I spot 1 or 2 others that are a little bit more subtle. But let's focus now on my outline of issues, and let's examine the contract claim. This is quite an interesting question, and I think you'll see that the outline that I suggest is an intuitively sensible approach to resolving the issues and finishing on time. So we ask up front the call of the question: is lab entitled to terminate the contract with DISCO? Then we focus on the preliminary issues, the agreement itself, and the parole evidence rule with regard to the allegations of discussions about extra time over holiday weekends that was raised by DISCO in the fact pattern. Then we consider the waiver issue and the unclean hands issue in 1D. I compare all of this to the alleged breach by DISCO, which I characterize as a minor breach, and all of this adds up to a conclusion that is favorable to DISCO and adverse to lab. I don't think they're entitled to terminate the agreement based on the facts that we've been given. Now, let's go to the PR aspect of the question, a somewhat shorter problem, but a little complicated too. The key idea here is the threat of criminal prosecution. We've got to deal with that ethical minefield. Although it is a relatively small minefield, it's a simple issue. We'll examine it. But the more subtle issue is a party has got to allow its lawyers to exercise independent legal judgment. And we can't just have the lawyer being literally a mouthpiece doing exactly what the client wants, because the client wants it. The attorney is the legal professional. The attorney has to make independent legal judgments. Now, as it turns out, my conclusion is that the attorney is entitled to do what the client wants in this context, so long as a couple of conditions are met. And we'll see in a minute or two what those are. Now, briefly, let's have a look at my answer to this problem. And again, I think the contracts question is the more interesting, and it's certainly the more complicated of the 2 calls of the question that we are dealing with here. So, again, we ask up front, is lab entitled to terminate the contract with DISCO? Notice that, up front, I lead with the facts. I indicate how the plaintiff alleges harm, the $9,000 loss, and that the lab seeks to terminate the agreement. I focus first on paragraph 8D. I explain what it is, and then we focus on the additional analysis below. We focus on the parole evidence rule and the integration of the discussion. My conclusion is that this contract is fully integrated, apparently, and that the extrinsic evidence of an earlier discussion by representatives of DISCO about waste disposal times over holiday weekends doesn't come in. Still, the other facts do, and those are more than sufficient to ensure that this contract is not going to be terminated. Notice the waiver section that I present. It only has 2 paragraphs, but I think you'll agree that analytically these are strong paragraphs. And notice how I find a home for all of the relevant factual details, and I also apply the law in a way that I think you'll find to be practical and responsive to the question presented. But the waiver situation isn't the only problem that the lab has in its efforts to terminate this agreement. The fact that lab itself did not perform according to the requirements of paragraph 8D also is worth our attention. And although I deal with it really only in 3 sentences here, I think you'll agree that they are well written and appropriate. Then I comment on the breach alleged against Disco, and I indicate that the breach is minor. And as a result, it wouldn't rise to a level that would justify terminating the agreement. And that's my conclusion. Lab is not entitled to terminate the agreement with Disco. So, next we turn to the PR part of the question, the part that I contend is by far the simpler part, but it still has a subtlety that we have to look at. The threat of criminal prosecution is the key ethical issue presented here. Is it okay for a lawyer to threaten criminal prosecution in order to advance a civil case? And the answer is, at some point, it becomes abusive process. But so long as the lawyer has a good faith belief in the validity of the allegations, it is fair game. Another ethical question posed by these facts is the duty to exercise independent legal judgment. We can't allow our clients to dictate how a case will be conducted. At the same time, we are employees of our clients, and we have to reasonably do what they ask, or they can fire us and get somebody else who will do the job the way they want. Still, it seems to me that the attorney has got to be careful about this situation and can't merely follow the dictates of the client without independently considering the situation. So, I conclude that it would not be unethical for the lawyer to use information about Disco's alleged crimes to help the lab get out of the contract. But, first, the lawyer has to independently verify the facts and make an independent legal judgment, concluding that following the lab waste disposal manager's stated course of conduct would in fact be the most appropriate legal thing to do for the client. So, we've just examined a crossover question with contracts and professional responsibility. PR is by far the most commonly crossed over topic. And you'll notice I didn't call this question a 3-way crossover, but I well could have, because the contract issues are framed around remedies. So, my friends, remember, remedies is the most important topic on any bar exam, and that is certainly true in California.